So hi folks, this is a nutshell about the civil procedure rules. If you've been following this channel, you'll be aware that every 2 weeks we have an interview, a longer session in which we also take in client calls on particular queries and conduct a little bit of a legal surgery. This is the nutshell of the last week's topic, which was the civil procedure rules. So we're going to cover the key points. I'm going to rattle through it all. Basically, this A to Z series, in which we cover pretty much every aspect of civil litigation, is based on the book that we've published, Flying Solo, to help you to represent yourself in the county courts of England and Wales. Small claims, fast track, multi-track. Okay. So what are the civil procedure rules? Well, they're relatively recent invention. We're just basically talking about a big overhaul of the system that took place because the powers that be felt that it would be useful to have rules and get rid of old practices and old terminology, old abuses of the previous system. Now, the first thing to say is, of course, you can go online and you can find it pretty much instantly, the civil procedure rules. Yeah, just Google them and they'll come up on the government website. And that basically governs everything that happens in the county courts. Yeah, so ultimately, you know, you can appoint a judge to a particular civil procedure rule that applies in your case and make it work to your advantage. Now, the critical thing to understand about the civil procedure rules is that there are various sort of areas, various complexities, various kind of aspects of the rules that can quite easily trip you up. But if you know them, it can give you basically the jump on your opponent. Now, the first thing to say is you don't need to know these rules inside out. Yeah, that's the job of a lawyer. And quite frankly, most lawyers don't know the civil procedure rules inside out, hardly at all, a lot of the time. So use as your touchstone the basic principles, yeah, at the very top of the civil procedure rules. Part 1. Whenever you've got a little knotty legal issue, use those basic principles as your touchstone. So, for example, one of them is that you should run your case at proportionate cost. You should assist the court in managing cases, yeah. So that's an interesting term, which is very commonplace now in civil procedure. Proportionate, yeah. So, you know, that sort of saying, when you're making a decision perhaps to make a disclosure application in a £5,000 case or even a £10,000 case, and that disclosure application is going to require your opponent to dig up documents from Australia, and you know they're in the hands of a third party, and it's going to be quite cross-jurisdictional issues and quite complicated to actually produce the documents, and you're going to have to make an application. The application itself is going to end up costing as much as the claim value it does, costing as much as the claim value does. You've got this issue of, well, is that really proportionate? Another area in which proportionality occurs is in costs. You know, when it comes to decisions about how much costs you get, because obviously the winner is entitled to their legal costs if they win, you've got the issue of proportionality applying to costs. So, you know, if you are struggling at any point, you can do worse than use a touchstone of what's called the overriding objective when it comes to civil procedure. Okay. Now, I'm just going to come on to some, you know, critical areas of those civil procedure rules that can be a bit of a pitfall for the unwary. Now, the very first thing to say is make sure that your legal research is up to date. Okay. Now, when I've got an issue, even though I'm an experienced lawyer, I will often go online and Google it. You do the same. So, but when you do look at that Google list, don't just click on the first thing that's up there. Check the dates, because the law does change. Take, for example, personal injury. After 31st of May, if the damages, i.e. the value in respect of a personal injury claim, is under £5,000, then it goes on the small claims track, and there are big ramifications for that, such as, keeps lawyers out. You don't get your legal costs even if you win, so there's no point in appointing a lawyer. Yeah. Now, if you were reading something about personal injury sector prior to that date, it would be, pointless. It would be less than useless. So make sure your resources are up to date. For example, on that issue, go to the Law Society. Now, the Law Society regulates solicitors in England and Wales. Put Law Society in Google. I have a personal injury claim of 5,000, or what's the limit, small claims in personal injury. You'll find some up-to-date information, because you can trust the Law Society to be keeping their website up to date. Yeah, to take an obvious example. Discontinuance is an interesting one. It often happens that, you don't really know whether your case is super strong or super weak. Perhaps your opponent has ignored you. And this applies obviously both if you're defending a claim and whether you're bringing one. So you discover that, let's say, the defence looks really serious, and you've missed out some complexity. That means you probably have to apply to amend your claim or take expensive legal advice, and the opponent's instructed lawyers, and you're like, I want to back out of this. How do you do that? Because the problem is, Google it, civil procedure rules, discontinuance. You discover that there's a little clause that says the person that discontinues is liable for the cost of the opponent. Yeah. So, well, you don't want that. But how about it's small claims? You're thinking, well, there's no lawyers in the small claims cost, so surely I don't have to pay my opponent's legal fee if it's on the small claims track, and it's a small claim of under 7,000. Well, if it's not been allocated to the small claims track yet, it's early days, you've just done the statements of case. If you discontinue at that point, your opponent, especially if they've got lawyers, is going to chase you for the legal costs up to that point, which could be quite hefty. So what do you do? Again, consult the civil procedure rules, and in essence wait for the court to allocate your claim to the small claims track, and then discontinue then. Yeah. And then if they ask you to pay their legal bill when you discontinue, you can say, well, it's on the small claims track. So that's hopefully dealt with, quite a tricky area of how, when and how to discontinue a claim when you think you're in hot water. Another good example of making the civil procedure rules work for you is costs. Yeah. So, let's say someone's brought a claim against you, and you just think they're being aggressive and they haven't got a lot of merit, and perhaps they're wealthy and they want to intimidate you and whatever. Or a counterclaim that may have no merit, but it's just designed to make it heavy weather for you and intimidate you off the ballpark. Yeah, a classic technique from a defendant. You're then worried, if it's on the small claims track, that you aren't going to be able to instruct a lawyer, because lawyers aren't meant to be involved on the small claims track. So you're worried you won't get your costs. But here's the thing: you need a lawyer, and moreover, you've got some costs, experts or court fees and whatnot, expenses that actually the loser does pay those costs, and you want those costs paid. Now, there's a clause in the civil procedure rules that says that, Google it, civil procedure rules, unreasonable conduct. And you'll discover that where your opponent has behaved unreasonably, you may find a judge awarding costs against them. So it's not an absolute, just because it's on the small claims track, that you don't get your costs. I mean, let's imagine a situation where you'd instructed lawyers and unfortunately the matter got allocated to the small claims track, and you've got a big legal bill that you were hoping would be paid by your opponent when you win. So you go ahead and win, but you're worried that you're not, you know, it's a commercially pointless endeavour because you're not going to get your lawyer's costs back, even though you get some money from your opponent. So that's where you drill into unreasonable conduct and see whether or not your opponent's conduct might have been unreasonable at any point of the proceedings or before the proceedings. So it's really interesting, and if you're a lawyer, and I don't advise you to become an expert and know the civil procedure rules. What I encourage you to do is to make them work for you at judicious points where it's complicated and the overriding objective doesn't seem to give you enough, to Google the relevant sections of the CPR and just drill in to the rules a little bit to help you at, you know, key and critical moments of your case. The most interesting thing about the civil procedure rules, and this is perhaps the big thing about English law as opposed to European law, say, is it's not prescriptive. You see so many of the civil procedure rules which comprise not just rules but also practice directions like guidance on the rules. You see so many of civil procedure rules finish with a clause that says basically, unless the judge orders otherwise. Basically, if you can persuade the judge to do something that contradicts what's in the civil procedure rules, yeah, the judge has the power to do what he likes on the day. Yeah, so always be going to court, for example, in the area of costs, prepared to argue your point, even though it may seem on the face of it that a civil procedure rule is against you. Okay, so there it is. That's a whistle-stop round the civil procedure rules. Bless them. And hopefully that's given you a little bit of equipment into you know, how to make them work for you. As I say, the danger of plugging the book yet again, you will find a lot of greater detail about the civil procedure rules in here. So, you know, put your hand in your pocket. We spent 2 years. This is a combined total of, you know, 40 years litigation experience packed into one book. It took us nearly 2 years to put it together, 2021, so it's very current. So please do contact us if you need help. If you go to the featured video on the channel, you will get an idea about how to go about using Court Wingman if you do need our help. The kind of the raison d'etre of this channel and the business Court Wingman is to help you to help yourself, to represent yourself in court without having to spend an arm and a leg on lawyers, but to provide you with, you know, a control tower or a navigator in the back seat to help you at critical points to make the litigation affordable if you do decide to represent yourself in court. Thanks for tuning in and look forward to speaking to you in the very near future.